Thank you once again. I hand over to Selma Gantry, the Director of ICTJ Office, who will proceed to the opening of today's workshop. I'd like to welcome everybody. We have a workshop on the exceptional circumstances and the status of promoting accountability for dictatorship-related corruption. We are going also to address the cases and files that have been transferred to the specialized criminal chambers by the TDC. We will be trying to address issues pertaining to ways of overcoming the current deadlock and the current situation. As a process of transitional justice in Tunisia, we will try to facilitate the process in a way to overcome the issues at hand. In order to achieve transitional justice, we have the Honorable Judge with us, Mohammed Aidid, who is an administrative judge and who is a former member and commissioner of the TDC. He is the deputy chair of the Competition Commission. We have also Professor Nicolo Seldoni, who will be with us. We have Leila Riahi, who is a civil society activist, and Mr. Wael Nifi of the investigative Katiba magazine. And we have also a leader of the organization countering corruption within the framework of transitional justice. So we would like to thank everyone for attending this workshop. Thank you. Thank you, Mrs. Selma. I'd like to welcome again our guests who joined us through the Zoom application, and all of those who are following us live on the ICTJ Facebook page. In the first session, Mr. Mounir Chedly, who is an expert in anti-corruption, specialized in the recovery of stolen assets, and the Honorable Judge Mohammed Aidid, who is a former member of the National Commission probing into corruption and bribery. He was also member of TDC. Mr. Muaz al-Wattani, who is the chief advisor to the presidency dealing with constitutional bodies and civil society. He was supposed to attend, but he apologized for previous commitments already made. The first session of today's workshop pertains to the status of cases of corruption and the issue of accountability with regard to transitional justice. TDC, by virtue of the Transitional Justice Law of 53, has investigated the cases of corruption and referred a series of cases to the specialized criminal chambers that is adjudicating these cases. We have various cases pertaining to corruption in various fields: energy, real estate, administration, many areas that TDC investigated thoroughly. Since the start of the specialized criminal chambers adjudicating these cases in 2018, we are fully cognizant that dealing with these cases raises a lot of hardships and is a slow process. Hence the need to come up with ways of addressing these complicated cases. And at a second level, we have also an issue of non-completing the investigative work by TDC, which also compounded the difficulty for TDC's proceedings. On the other hand, there are other cases pertaining to financial and administrative corruption that have been referred to the economic, financial, and judicial poll to investigate those cases. And we all know that not all the cases have been processed. Only out of 300 cases, only 10% of the cases that have been referred have been disposed, and therefore the process is still going on. Today, there are some social protests that raise the slogan of dignity and liberty and combating corruption. And after the announcement of suspending the 2014 Constitution of the Republic of Tunisia, we found ourselves in an exceptional situation, dealing with exceptional measures, compelled to address the grassroots for the protests of the 25th of July, which is the widespread corruption in the finance and administration. And therefore, we are required to promote accountability to address corruption. But we have also available data, a set of cases that are adjudicated by the specialized courts dealing with financial and economic corruption, and the judiciary and the courts dealing with transitional justice pertaining to financial and administrative corruption. And we have the reports of 2011 for the Commission probing into corruption and bribery, and the report that contains part of financial and administrative corruption, ruling out, not taking into account other aspects pertaining to corruption. The case of the French-Tunisian bank, for instance. Today, we have Mr. Mounir Chedly, who will address the part pertaining to the status of the cases of corruption that are being adjudicated by the specialized criminal chambers. And Mr. Mounir Chedly, welcome again, and you have the floor. Sorry, I cannot hear the speaker. Please, I cannot hear the speaker. I cannot hear the speaker. I cannot hear the speaker. We cannot hear the speaker. Cases of financial corruption are connected to the stolen assets abroad. that is able to deal with this. But the problem is that its work was limited to only 4 years. In 2015, the investigation was finished and the cases were referred to the Commission dealing with state litigation without providing it with the resources. And therefore, the State Litigation Commission cannot prosecute the embezzlement of Tunisian assets abroad. But the problem that we encountered was the promulgation of the administrative reconciliation law in Tunisia that contributed to impunity despite the establishment of a violation of the law, of the promulgation of law number 62 pertaining to reconciliation in the administrative area, whereby based on Article 86 and 96 of the Code of Criminal Proceedings, people shall not be held accountable for administrative violations, provided that they never received any gains. The issue is not about the legislation, but the way the legislation is enforced in the courts. Usually, an expert is appointed to establish whether the person who was a minister during the office of the ministry. They verify during the 2 years of office whether that person reaped any benefit. But in Tunisia, most of these assets are smuggled out of the country, and the expert evaluation is only limited to Tunisia. They check in the banks, in leasing companies, in the stock market, but they find nothing, because all of the briberies and all of the illegal and illicit commissions that have been smuggled out of the country. And therefore, I consider that transitional justice at this level played a key role. Why? Because with regard to the former president who died with his death, the case is dropped and the legal prosecution is terminated. For Hassan Trabilsi and the cronies, he's in law, who is in France. Trabilsi is now in Italy. Said Al-Aqabi is now in France. The Tunisian authorities could not recover any of these persons because the status or the situation of the Tunisian correction facilities does not allow the deportation, even though the crimes have been thoroughly established. That's why I personally believe that the legal system of transitional justice enabled to avoid this reconciliation and settlement with these perpetrators, because among the principles of transitional justice, we cannot invoke double jeopardy. We cannot invoke ex post facto. We cannot invoke a previous amnesty, and therefore we can conclude that the perpetrators of violations of financial offenses, they cannot invoke the statutes of limitation or the ex post facto or previous amnesty to be held accountable before the specialized criminal chambers. The latter have priority, and out of the principle of subsidiarity, they have primacy in jurisdiction. And the specialized criminal chambers are entrusted with the cases of transitional justice cases. I just wanted to focus on the practical level regarding the counts of accusation and the indictment briefs. The referral of the cases to the specialized criminal chambers by TDC, these cases are complex. I take the example of the indictment brief of number 35. TDC investigated all of the cases of financial and banking corruption for 23 years, which makes the court overburdened and unable to cope with this load of cases because the specialized criminal chamber, it's the criminal proceedings that apply, that do not allow the dismantlement of such cases. And therefore, there have to be recommendations during this transitional period, because the President of the Republic can issue decrees in order to overcome these hurdles, and therefore the specialized criminal chambers are at a deadlock for the time being. Secondly, there's a nice initiative from the specialized criminal chambers regarding the gross violations. As you know, in gross human rights violations, those who committed torture, those who they refused to attend the hearing, despite this, the fact that they had been duly subpoenaed by way of they have been served subpoenas, and some of the specialized criminal chambers in Nepal, they enforced one article, which is Article 142, that provides, in case of abscond of the defendant, the court could issue an arrest warrant and order and it could order garnishment of his assets. This procedure has had a good effect, but the law enforcement officers really did not follow. And there is a proposal to apply the transitional system that happened in Morocco. Unilateral reconciliation cannot allow any confrontation between the perpetrator and the victim, and therefore we can provide for reparation. But I personally consider this as a good initiative to enforce Article 42 to authorize to enable those the perpetrators to take into account the court procedures, and therefore this measure has been enforced in many courts, of course, this garnishment procedure. But each judicial year, the members of the specialized chambers are subject to turnover and reshuffle, and every judge needs training in this subject matter, and this issue is raised every year with the judicial transfer movement. That among the other obstacles that hinder the work of the specialized criminal chambers is that the indictment briefs, the court refers these charges, these traced by virtue of international conventions, but these international conventions are not found in the domestic law. And for instance, enforced disappearance, Tunisia ratified the convention since 2011 by order and by decree as an independent crime, as an autonomous crime, because we have provisions in the penal code for the sequestration and kidnapping of a person. Article 237, 238, the crime of harming the public, harming a public official during the exercise of duty, the sequestration without legal warrant. But as an autonomous crime, the Tunisian domestic law does not criminalize enforced disappearance, and that's why I suggest recommendations regarding the dismantlement of cases and then a call to criminalize enforced disappearance as an autonomous crime, because for some other crimes we have certain details, but not this one. Thank you for listening.
Thank you very much for this introduction related to the status of cases before the competent courts and how complicated and the composition of or the change of composition each time. As we said in the beginning of this workshop, some of the data we have are the final reports of the Truth-Seeking Commission on corruption and bribery, and also the IVD report that give us some data on how widespread the corruption is at the level of the state institutions. And now I give the floor to Mr. Mohammed Ayedi to tell us about how to leverage these reports and how important they are for the current circumstances and current period. Thank you. I'm elated to participate in this seminar with the participation of many of my colleagues in this panel and on a very important topic. So the role of control reports from IVD or from Truth-Seeking Commission are related to accountability, and accountability itself is a legal concept in itself. It's to acknowledge that everyone should be subject to or should be held accountable for any deeds they committed, and accountability can also have a political meaning, but in short it's about assessment and also to also hold accountable the system, to hold accountable individuals, etc. That's why accountability is really important. And the question that we can ask here is, did these reports help achieve accountability or not? Or to what extent did these reports or actions by IVD and the Truth Commission, the Truth-Seeking Commission, have really contributed to unveiling the deeds of corruption, etc. And if not, was there a failure at some point, or what exactly happened? So if there are strengths, of course, we disclose those, and if there are weaknesses, then we do as well. This also relates to the economic reality. We can ask a question: is the intervention of the President of the Republic based on Article 80 of the Constitution, did it have an impact? Also, when we look at the review of these institutions in the Parliament and in the government, it could be a justification according to the presidency of the government. And even the Prime Minister was appointed today by the President, and she was assigned to fight against the corruption. So we have been experiencing for more than 10 years now, through the National Committee, through the seizure committee, through the different procedural accounts, and through the Court of Accounts, etc. So so these reviews or these revisions by the President today is an acknowledgement that we failed before, and that we need to come up with exceptional measures to go forth. I don't think that's true, in my opinion. Tunisia has had a successful democratic transition, and the consecutive governments, they have held up the corruption. They used also corruption to attract money, which became political money, and the previous governments, they have also used corruption for blackmail against businessmen, etc. There are some governments also that retaliated against people based on corruption. Some of the MPs also became members of the parliament, and they were of course they have committed some crimes, and some of them today are imprisoned because of that. So many of the governments, the preceding governments, they have been involved in these practices, the same practices that we are fighting against. Also, the previous minister who was in charge of fighting corruption, there was an issue with him, and he said that the prime minister was in contradiction to the interests made by the minister. So, and of course, this case was referred to the court, and we know all about this issue. We know also the case related to face masks, for instance.
After resigning, he refers the cases to the justice and complains about his prime minister. These are the real issues, and this reluctancy in dealing with the files of corruption has been noted even at the level of TDC. How? The Truth and Dignity Commission was granted by the lawmaker some powers to the extent that people called it a state within the state. All the crimes investigated by TDC cannot invoke the statute of limitation or the ex post facto or double jeopardy, and all the archives have been given to TDC. It has its mandate that extends to touch all human rights violations, including the crimes of financial corruption. And as a commission, it can adjudicate cases of financial corruption, investigate cases of financial corruption. And there is a commission called the Committee of Functional Vetting and Combating Corruption. Therefore, to pinpoint any establishment or institution that is suspected for corruption, and to really hold to account the perpetrators of corruption, the investigation of financial and administrative corruption. More than 1,670 cases have been referred to TDC, but we have not reached any arbitration or reconciliation. Only eight arbitral awards have been reached but have not been enforced. These arbitral awards now have become a burden to the state, because the state had to really give up its rights, and the state is now required to provide some of the funds that have been confiscated by virtue of these arbitral awards. Will the state now give up certain funds that have been confiscated, or will it benefit from the arbitral awards that are likely to really provide revenues in order to provide reparations that have been decided by virtue of these decisions? Because a large part of these right holders those are people who have lost everything, and they were compelled to migrate because of the human rights violations. So saying that accountability is an easy issue, and that we can say that accountability could be summed up in prosecuting the perpetrators and putting them in prisons, or or to pardon them. I don't believe that the President of the Republic is not attentive to this important issue, that countering corruption, the approach has to rely on two levels. The prosecutorial approach that requires in-depth reviews at the level of the Code of Criminal Procedures, and I'll tell you how. And secondly, at the level of the prosecutorial approach, our legislation and the structure of the Tunisian justice does not provide for effective adjudication of corruption files. We are dealing with very ancient procedures. Investigative judges have to enforce the laws. Why are the courts considering the corruption files of TDC? Because our procedures are the culprit, and there are no other reasons. As my colleague has said, the judicial poll has been set up in a late fashion by virtue of a memorandum. I worked in TDC and in the Anti-Corruption Commission. Now, there have been precise cases that have been referred, because that's why the Tunisian justice system has been working according to traditional fashions, and that's why it has stumbled on many occasions. And the wake up, if you like, move came a bit late in December 2016, and they started in 2017 working with 10, 15 investigative judges with a penal code that needs really a revision and needs to be reviewed. And this is a call for the government to focus on this point, that is to review the Code of Criminal Procedures as soon as possible. The cases that have been referred to the Public Prosecution Office are standing there without any delay or any deadline, and therefore we need to remove the investigative stage and go directly to the court procedure directly, because the purpose is to reduce the deadlines. The only cases that are adjudicated are cases of transitional justice, cases that have been referred by TDC, arrived to the specialized criminal chambers. They are taking preeminence over the other cases, because the cases referred by TDC do not go through the investigative process, and they do not bump into the investigative stage and the arraignment chamber, and therefore it is necessarily referred directly to the trial stage. That's why the cases of the specialized criminal chambers are dealing with them at the trial level, and therefore at the level of the National Anti-Corruption Commission, we included a proposal that to address cases of financial corruption, we have to have a specialized public prosecution department when addressing the draft bill for the good governance and anti-corruption for the Constitutional Independent Commission. We recommended a special public prosecution that works within this commission, so that when that commission refers that case to the courts, it goes directly to the trial stage without going through the investigative process. Because if we go through the investigative stage, we have to, that would take much more time. We also recommended that the investigative judge deserves technical assistance. The judicial poll that was established in 2016, there was also a legal provision for the establishment of a technical department. These are experts in fiscal matters and insurance to be there at the disposal of the investigative judges in order to help them achieve expert evaluation. the executive order has been issued, but the incentives to attract people to work and make by secondment or an expert accountant or certified accountant would go to this office. But what are the incentives so that this expert could really work and provide expert evaluation in the phone? There has to be incentives to attract expert evaluation staff. The annual judicial transfer includes the judicial poll, and a lot of experts, after they spend time working in the judicial poll, they are transferred to other positions, and other people are hired, are appointed, which requires a new return to square one in terms of training. And therefore, we have to really get acquainted with the cutting edge technology in investigation. There are those perpetrators of violations are really armed with all technology in order to really avoid crimes and to escape any prosecution or and therefore talking about accountability requires at the prosecutorial level, we have to enhance this approach by effective tools. This should come under the framework of the state, and it cannot be the sole initiative of the president. There has to be a government, a clear-cut program under the government. The new government will be headed by this woman whom we trust. We are aspiring to a good job on part of this head of government, but her policy shall be based and should be based on reviewing all of these aspects. The second aspect that we overlook, we have so many reports and many cases that have been referred to the courts, but the performance is below standard. We have also the preventative approach within the Anti-Corruption Commission. We pinpointed this problem, but we suffered a lot because of this. The commission has to go to the different areas. I personally, at the level of the board of directors of the Anti-Corruption Commission, we have to focus on this preventive approach, which is not about haranguing. It is a policy that requires from the government to define a strategy. It requires the dismantlement of the corruption system, because the corruption system cannot be dismantled by the sole initiative of the judge. It has to be dismantled by a well-designed policy of the government. It has to be dismantled through legislation that need to be reviewed. It has to be dismantled through institutions that work in harmony and not in conflict. We even witnessed representatives of the state of Tunisia working within the organization tasked with the recovery of stolen assets. There was overlapping jurisdictions and disputes over jurisdiction. Some would say, we want to work this way, and others want to work the other way. And this even went public. We heard of the confiscation cases. A minister of the public domain who says that there are people who are reaping benefits from this file. We have to review the legislation, of course. There is legislation that needs a review, like the Code of Criminal Proceedings. I was expecting the President of the Republic to order the promulgation of legislation of an executive order to it could be published. I was expecting the President to appoint members in the prevention department. This had not been done in 2011. It just requires a procedural decree. Since the 14th of November 2011, there was a decree promulgated that there is an anti-corruption commission that works, among others, as the beating heart. I was expecting the President of the Republic to appoint the members of this body. I couldn't expect the President of the Republic to close the look. I was expecting him to appoint a head of this department and to provide for the establishment of a preventive body. And if anyone fails to do the job and discharge the duty duly, or if there is corruption within that department, everybody could be held accountable. Nobody could enjoy impunity. Everybody shall stand accountable. Everyone has to assume responsibility. Shawkat Bib or any person has to fulfill responsibility and bear responsibility about the state. I was expecting the President to appoint the prevention body within ILUC. I couldn't expect the Minister of the Interior to take personal initiatives, because the Central Commission has been closed down by virtue of a decree. What will become of the statements and the documents that are within this department? Who will be responsible for the conservation of these documents? I was expecting the President of the Republic that the technical that he would appoint a technical department for the judicial phone to promote and to reinforce the resources of the judicial phone by virtue of decree, in order to dispose of financial corruption cases within a maximum period of 1 year. All of the corruption cases shall be disposed within 1 year or 1 year and a half. This could be done by virtue of a decree. The settlement of cases by way of settlement, instead of having people languishing in prisons. In 2011, there was the criminal settlement was authorized in 2011. Any person returning the money to the state could benefit from we can really prevent that person from sustaining custodial punishment. And we also spoke about the Prevention Commission and for the protection of whistleblowers in 2011. This draft project was in 2011, and the Commission was dismissed as being working in favor of certain persons. The report of the Anti-Corruption Commission contains all of the items regarding the prevention body and the prevention approach that we recommend. Even our colleague Kamal Ayedi was advocating this approach, but his words had fallen upon deaf ears in that regard. I recommend that anyone keen on addressing these files, that they adopt the preventive approach without disregarding the prosecutorial approach, because the system of corruption is not necessarily the responsibility of the judiciary. It has to be also the responsibility of the state, and we have to review all legislation that contains loopholes that could be used by the perpetrators to ensure impunity. Work cannot be individually. There has to be coordination between the states, and each institution has to be provided by the necessary resources. like the National Anti-Corruption Commission. We recommended that it use the system of reconciliation and settlement, publish the executive order, and to ensure access to information. This executive legislation is used by politicians not to enforce certain legislation. What would be the use of legislation in the absence of any way to let people know about that legislation? If you want to really serve the country, you have to exhibit a high degree of transparency and to bear your responsibility. Otherwise, you have to go to do a different business, because when you embark on politics, you are there to serve the public and you have to declare your assets, and you should never hesitate to publish the declarations by executive decree. It will it will affect Farfer, Mishishi, Shahid, who never wanted to really publish that declaration provision, because they will be compelled to publish their declarations, and their alliance, the MPs, they pushed the Prime Minister not to publish that. They would, inside the Prime Minister, the head of government, to publish any thing, but not the personal asset declaration. Which Arab state that has 200,000 declarations that are under reservations? Tunisia is the first Arab country with that the fifth Arab country in terms of anti-corruption. That's the ranking, and the first in North Africa. Tunisia has a legal framework. Italy published and promulgated a law protecting whistleblowers right after Tunisia. Within the anti-corruption commission, we have always been adamant that the legislation must be reviewed. Our ranking in 17, we are ranking 64 in 2020. These are confirmed statistics. We cannot blame the Anti-Corruption Commission or TDC that did not do its job. There are reports, but there is no follow-up. Like the Court of Auditors, it is provided with some powers, and we speak about, the Court of Auditors being silent on certain cases and files. The Court of Auditor judges are bound by the legislation, and they are bound by the procedures, and lengthy procedures, in fact. The lawmaker has had to adopt an approach that would shorten the deadlines for such cases, because these are urgent cases. And therefore, when you legislate certain procedures, these procedures have to be compatible with the nature of the crime. But if you provide for a trial system and then an appellate procedure, and then you have to subpoena a person, the Court of Auditors does not have a procedural legislation. It has the code that governs the adjudication procedures. They don't, it is applying the procedures that are applied in the electoral code. The Court of Auditors doesn't have its own code. In procedural terms, the Court of Auditors needs a code, and that also requires a review. I don't want to, of course, we can go deeper into the discussion, but thank you very much for this information. Thank you, Judge Hamid Ayedi. You have in details pinpointed that the reports drafted by the Anti-Corruption Commission and TDC could be important at the time being through the enforcement of executive legislation. And even the President of the Republic also made reference to this report. And that's why I wanted to draw the attention about the importance of these reports. If we can have a clear-cut policy in terms of anti-corruption and promoting accountability, we can adopt both approaches that you just mentioned to promote this process.
As we said in the beginning of the workshop, Mr. Moaz Wardani was supposed to be a guest. He's a part of the presidency of the government on civil society. He was supposed to speak about the expectations of the civil society and the effectuation of Article 80 of the Constitution on the 25th of July 2021, but he, of course, did not make it because of previously made commitments. So I'm going to ask this question to the attendees here so that we can discuss this topic. And so how do you expect what do you expect the impact of the Article 80 in fighting against corruption? And I will start from my right, Mr. Wael Walifi, who is an investigative journalist and specialized in investigating corruption. In your opinion, what is the impact of these special circumstances on corruption in Tunisia and fighting corruption in Tunisia? Thank you very much for your invitation. I will speak more in depth later on about these exceptional measures, but I can say that these exceptional measures will lead us to where we want to go. So within the transitional process, we have some concerns because the discourse of the president is concerning, and other times he says that he's going to fight corruption. So there is this kind of fluctuation. But what we can assume is that this approach adopted by the president is a singularity approach to fight against corruption. He did not per se speak about justice and other topics aside from the anti-corruption committee. He also looked at the recommendations of the report, in Luke report, and he also spoke about a number of businessmen, their numbers, and there are of course some skepticism in relation to how true those numbers are. But I think that the president has a clear pathway that he's following, and I expect that this will be translated in the actions of the government, and will adopt the policies and the decrees issued by the presidency of the government. And such decrees are being drafted and will be promulgated soon. Thank you very much. So our friends from Zoom, if you'd like to take the floor, please raise your hands by clicking on the button at the bottom, so that we can take a list of speakers and give the floor accordingly. Mrs. Leila Riahi, I ask you the same question just to open up the discussion. What is the impact of effectuating the exceptional measures of Article 80? I will use the same term used by my colleague Wael, which is a singularity approach. So, of course, this discourse is about perfection, and we have to remember that the president reached his position based on his discourse of fighting corruption. So, and he was up against someone who was a symbol of corruption. So that's something that allowed him and helped him to become a president. So, in my opinion, the president's vision is not comprehensive. He only looks at things from a legal point of view, and he is adopting exceptional procedures and measures in a legal way. But I think that when dealing with corruption, it should not be dealt as such. The economic and political system creates corruption. That's the main issue. So I would like to speak about the judicial system as well. You said that a decision could take up to 1 year and a half, but I think that the judicial system in Tunisia, with the technical and human capital and resources, they can deal with all of the corruption-related cases in 1 year and a half. So, of course, when something comes to public finance, then we need to fight against this corruption that is plundering the public finance, and we need, of course, to look at this very closely and to revert or to recover the judicial and the economic system, even the civil system itself, in relation to the civil society organizations and the national institutions. So we cannot really deal with them as individuals. No, there is actually a system that is based on mechanisms that facilitate and create corruption. And even when we talk about the reports and the balance of power, then this led to what we see today, that this yields some easy opportunities for corruption. So this is a war, and I don't think that only exceptional measures will address this. For example, when we look at the basic commodities distribution, we look at the storage facilities, for instance, and we really revert back to good distribution networks and good distribution storages that are devoid of corruption. So that's the simplest example I can think about right now. And the problem of corruption is much deeper than is apparent on the surface. So these procedures are not up to the task. This populist current is only temporary, but we already have the tools to fight against the corruption, and the current way of doing it is not the correct way. We also remember the frustration we had before the 20th of July, but I think that will be amplified even more in the coming days. Thank you, Mr. Mohammed. Would you like to add something? Yes, I think that the exceptional measures taken by the president have come as a reaction from the president towards the existence of political corruption. So this is something that irritated the president and pushed him to take these exceptional measures. We also saw that the parliament was intertwined with political money, etc. So the president saw it opportune to freeze the activity of the parliament, and this has been also accompanied with some discourses from the president on prosecuting all those responsible for the grave situation that the country reached. There were also other issues related to conspiring from foreign parties against Tunisia, etc. So when we look at the decrees, for instance, Decree 117 of 2021, it illustrates the policy of the state, and it's not only related to imprisoning the people who have committed unlawful deeds. So we want of course a fair trial for everyone. That's the purpose, and this government should give a fresh breath to the new decisions. It should be able to revise legal text and to support and consolidate what the judicial poll has been doing. And this should be, of course, good news for everyone. But this singularity or someone who is a vigilante or working by themselves is not very useful on the long term. And I don't think that this is the best way to do things. I think that working on an institutional level is the way to go. So the most important thing right now, for example, is to work against corruption. There are many ministers and prime ministers also have spoken about this and say that, for example, the citizens will be able to issue their administrative paperwork remotely or online. But this has been repeated time and time again, and yet this has not become the reality until now. If there is for example, if we were talking about auditing, then if we ask a ministry, for instance, how many administrative cards do they have, then they wouldn't know. So let alone having a specific audit for that. We always see numerous reports that are issued time and time again, but we feel like we are in a vicious circle. So when the previous governments reached the power positions, they went back on all of what they said before, for example, in terms of fighting against corruption. That's my opinion. Thank you. Concerning the exceptional measures, I personally think they are cutting ties with what happened in the previous period. I once wrote an article called Impunity Through Public Forces, and I gave examples of cases from the parliament, and all of the details from these cases shows and proves that the MP in question took money from the previous ruling regime family, but then the cassation court would adjudicate that and would say that the currency that was deposited in the bank is clean money because it has clean serial numbers for the bills. There was also another committee that was established back a few years ago to find solutions for money laundering, etc. But all of these efforts have turned into the opposite. They have become opportunities to do the exact opposite of what they have been established to do. So there are people who have cases in the Court of Appeal and in other courts, and yet they are still in decision-making positions. In the previous years, the corruption has become very widespread, even more than it was in the Ben Ali regime. So we have seen a lot of cases of corruption in state institutions. And when we file a complaint to the administrative court, then they would refer us back to the civil court, etc. So we have reached a very strange phase, I think. But right now, maybe some people are frowning upon what's happening, but it's much better than what we had a few months back. Thank you very much. I think that Mr. Almi asked to speak. Can you hear us? Yes, thank you. Hello, everyone. Welcome to all of our dear guests. Can you hear me? Hello? Mr. Hadi Qulsi asked to speak. Can you hear me, Mr. Ezer? Hello? Could you please raise your hand through the button? We can see you, Mr. Almi. Please unmute yourself. My mic is open. At the bottom of your screen, there is interpretation language. Please choose Arabic. Can you try? Yes, we can hear you now. I've been on the Arabic channel since earlier. Okay, thank you all. I hope you can hear me. Mr. Almi, at the bottom, please choose Arabic so that everyone can hear you. Now, can you hear me? Hello. Yes, now we can hear you. The floor is yours. Please be brief in just 2 minutes. Go ahead. Thank you. Thank you all. Hello and welcome to our dear guests. I don't have much to add to what has been already said, but I do remember a poem by Maruf Rasafi. Is that everyone is trying to get the positions and they're trying to do as best as they can. And they do that behind closed doors. So when we speak about these specialized chambers and corruption, things are happening behind closed doors and we do not see any real outcomes. What we can conclude with is that the political corruption is an incubator for financial corruption. And I think that with the adoption of Article 80 of the Constitution, can we maybe see more clearly the rift that has taken place? Because effectuating this article can be lawful or unlawful, depending on the way you see it. You know also that my motto is to fight against political and financial corruption, but unfortunately, and since day one, I felt that things have deteriorated since the 25th of July. We all know the list of misdeeds and the list of corrupt people, but and on the second day they went back and they rescinded their list, and the threat level was reduced. We do have some cases that are ready. I was expecting for the president to strike back in force, especially in terms of corruption, at least to give a speck of hope for the people in resolving the issue of corruption. Of course, this should be a priority, especially that these corrupt people, they are already known, and there is a list of these people. So we do know specific names that could have been dealt with. I can give you another example. The Mashishi, the previous prime minister, he wanted to appoint consultants of Munji Safra and others, but the president told him no, because the people he would have chosen are implicated in corruption-related cases. I can also give you other examples. Today, there were 3 sessions in the specialized chambers that have been postponing the cases because the quorum was not met. So the judge would come to the court, and they knew about the postponement, and the judges were happy of this postponement because they knew that if the trial occurred, then those people would walk free. So when we speak about fighting corruption, then this should be of paramount importance. We have many comparative examples that succeeded in such endeavor. And the number of corruption cases have gone up since the regime of Ben Ali, which is contrary to what we want to see. We have seen so many things that undermine the picture of Tunisia in front of the world. So this is a big question mark for me. Is there anything that is preventing fighting against corruption, or are they normalizing corruption, or what's the issue here? Because we have seen that all of the successive governments and the political parties, they are normalizing corruption and not fighting it. And hopefully we can get rid of this curse soon. Thank you, Mr. Almi. I give the floor to Mr. Hedi Polsi. Go ahead, sir. Thank you very much. Hello, everyone, and thank you for the invitation, this kind invitation to participate and to benefit from your presentations. And after listening to the presentations, and even though I'm listening to the same data, the same programs, the same reports since 2011. As I have been monitoring what's happening at the level of the state and at the level of civil society, and I've been listening to the same discourse. And until now, we are in a deadlock in the face of this corruption. I have a comment and a proposal. I think that after the appointment of Mrs. Najla Boudan as a Prime Minister, I would like to suggest to you to send her a letter including the recommendations, or to attract her attention to incorporate the transitional justice process in her plan. Maybe this would be done by this new Prime Minister, as it was disregarded by previous prime ministers. Second, we should give priority to the specialized chambers, and Mr. the Judge here said that there should be a direct adjudication of cases, but as we can recall, there have not been any cases that were adjudicated in the recent history. So I think that the justice itself and the system itself can be a hindrance to serving justice itself, which is a paradox here. So we need, can we work on a first 1 degree basis, or 1 degree of litigation, or should we resort to 2 degrees of litigation? I think that this is the missing link is the citizen. If the citizens do not contribute at our normal and regular levels, through administrative letters, through our administrative requests, if we do not contribute to reduce corruption and eliminate corruption at an everyday life scale, then we shouldn't be expecting corruption to go away by itself. So we should start level by level, from the citizen to the administration, and then we reach the higher level of the pyramid. So at least we can start at our level, even modestly. Finally, if we want to counter and combat corruption, is to combat political corruption first, because political corruption is a contributor to the dissemination of corruption of all forms: administrative, judicial, communication, economic, etc. So if politicians who conduct their jobs and stay away from their own interests and only serve the public interests, then this will help us to prevent a big portion of corruption from happening, especially that we see the informal sector that is supporting corruption from its side. Thank you, Mr. Hadi. And before giving the floor to Mr. Mohammed Ayedi to answer, our dear colleagues, if you'd like to comment or to ask any questions, kindly raise your hand so we can see you. At the same time, we're going to send you a form online. So we're going to put it in the chat box. Please click on the link and choose your language, English or Arabic, and fill out the form. Mr. Mohammed Ayedi, go ahead.
Regarding the transitional justice cases, I reassure Mr. Hedi and the system of transitional justice has constitutional guarantees. Article 48 says that the state shall undertake to enforce the system of transitional justice in all fields. It's the state of Tunisia, any government working under the state of Tunisia is required to enforce the system of transitional justice and to complete this system. It's not TDC, but the system of transitional justice with all of its branches, including the trials that are still going on. And therefore, the state shall be required to fulfill the process of trials in accordance with the constitutional requirements in terms of facilitating the work of the commission, in terms of the appellate recourse. That will not happen. Article 108 of the Constitution guarantees the dual degree litigation, which is one of the substantial guarantees and safeguards of due process and fair trial. And therefore, all litigants are entitled to proceed to the higher level of jurisdiction in case they are not satisfied with the initial level. If the decrees, if we suppose today that there is no establishment of appellate jurisdictions, if I am aggrieved by a certain decision at the trial level, I can apply my right by virtue of the constitutional safeguard of Article 108 of the Constitution, and therefore I can lodge an appellate procedure at the appellate court, and therefore the delay shall not be prejudicial to any attempt to proceed at the specialized criminal chambers. This cannot happen because it is inconsistent with the Constitution. You are surprised because there are no decisions handed down by the specialized criminal courts. But I have not been following the cases, but I understand why the judges are delaying the cases, but they are founded, these delays are founded and based on objective reasons like the skeleton of staff in terms of the judges assigned to these tasks. The files are not ready for final decision, and based on my knowledge, there is a difficulty for the defendants to attend and to appear before these trials. And therefore, the subpoenas have been ignored by the defendants themselves, which is intentional in certain situations. People refrain from appearing before these specialized criminal chambers. And I do not believe that cases are ripe for disposal and that they have not been that are ripe for disposition and that the judges did not dispose them. There are hardships in the sense that the indictment brief is referred by TDC, and it is the only brief of indictment regarding a certain case, but the defendants are numerous. It could be 100 persons, and therefore the adjoiner procedure cannot be applied because punishment is individual, and therefore the judge has to separate them out and cannot proceed within the adjoiner process. And the judges are not familiar with these new kinds of litigation. They are encountering legislative hardships because the legislation did not provide for certain penalty. Nulle crimen sine legge, nulla pene sine legge. Therefore, the judge is applying the penal code. Of course, he has to abide by the penal code. The judge cannot proceed on his own. These are some of the hardships and the hurdles encountered by the judges in enforcing the adjudication of the cases referred by TDC. The lawmaker has to step in to provide for certain amendments, like, for instance, the crime of enforced disappearance, which is not provided for in the penal code, or a list of defendants of 100 persons. You have to proceed individually, and you have to subpoena the person who might ask for a continuance, and this will complicate the matter. Quite fortunately, the transitional justice litigation is safe from the process of investigation. Picture this process required to proceed with investigation. I think we will not do anything. Thank you, Mr. Mohammed. I now hand over to Mr. Rida Barakati. Mr. Rida, if you can hear us, please. Please unmute yourself and pick the Arabic language, please. You have the floor, Mr. Can you hear me now? Thank you. Thank you very much. First of all, I would like to renew my thanks for the Office of ICTJ that provided us with this opportunity to really deal with the transitional justice and counter corruption efforts. I'd like to thank both speakers and all both lecturers who have provided us with thorough clarifications in technical and legislative terms of this case, or this file, which is complex and intricate and intertwined, which is quite difficult to decode. We cannot really decode. This is the picture I perceived as I was listening attentively to the speakers. I won't add much because I'm no expert in this regard. What I would like to reiterate is that everything comes down to the political will in the end. And first, transitional justice, since the promulgation of its law in 2014, followed by the 2014 elections, the power balance shifted towards Mounir Chedly and then to another. And the former president of Mounir Chedly was known for his hostility towards transitional justice. He endeavored to really obstruct the efforts of transitional justice. You all know in technical terms the promulgation of the administrative reconciliation law that guarantees settlement for administrators who were implicated in corruption and concession of public funds and embezzlement of public funds. There was no political will. There is a political will in fact to undermine and to disrupt transitional justice. The second party, the Another party, that is concerned with transitional justice, and because of the development of the political roadmap and it decided to sacrifice transitional justice and to broker alliances with other sides for mutual cover-up, and which reached the point of appointing one of the major corrupt figures, Mohammed al-Ghariyani, who became the special advisor in transitional justice to the House, to the Speaker of the House. This is a scandal, and it is prejudicial to the process of transitional justice. last week, some were reluctant about this name and then accepted the label and said that transitional justice is based on reconciliation. I sent him a correspondence through the High Commission that reconciliation comes following other requirements like truth-seeking, reparation, accountability, and then comes reconciliation. But to jumpstart the process and go directly to reconciliation, this cannot come under the framework of transitional justice, and it is inconsistent with the spirit of transitional justice. There are various experiences in other countries. Other countries may have advocated this approach, but in Tunisia, we really tapped into these comparative experiences and we fine-tuned our transitional justice process accordingly. On the other hand, it's about the current situation. That is the post-25th of July 2021. And before I address that, I'd like to remind that the process of transitional justice has been pursued despite the attempts to undermine and disrupt it. Thanks to the resilience of the coalition of the civil society and the struggle of all of its advocates, like the International Center of Transitional Justice and the High Commission of Human Rights, along with other human rights activists and honest media figures who really defended the process in addition to the free men and women of Tunisia. The media in Tunisia, since the promulgation of transitional justice law in 2004, managed to tarnish transitional justice in the minds of the bulk of the public opinion at home and concised it into matters in the figure and the person of the president of TDC, that transitional justice was by no means the Truth and Dignity Commission, but they summed it up in the prison, and they summed it up also in financial and pecuniary reparation. I don't like the word compensation, but it's financial reparation. Whereas the process of transitional justice goes well beyond this reparation and it contains many other stages. I'd like now to come back to the post-25th of July, which is a real issue. Because if the situation before July 25 was by no way a situation that anybody would come to regret due to the situation that we all know about, and the closure of the parliament is no longer acceptable, and the parliament has turned and shifted into a circus, and there was no government for the there was no program for the Mishishi government, and the Mishishi government was really showing deep hostility towards transitional justice. So the post-25th of July situation, we know that the President of the Republic spoke before the presidential elections. He has his own perspective. He never speaks about transitional justice. When he dismissed certain officials, he did not forget the Dean Abdelrazak Kilani, even though he is not officially dealing with the transition justice. He is dealing with the revolutions wounded and the martyrs. He dismissed him, and he has his own perspective, which I sum up in his statement the most corrupt shall be sent to the most marginalized area. He is now trying to provide some funds to build some schools and trying to hire a few people to find jobs. This is not really what needs to be done. In terms of transition justice, the President of the Republic has his own perspective, and which shows that the funds of the states have been stolen by corrupt people. The state has its own departments that are tasked to recover the assets. It has its own institutions and it has its parliament to decide whether marginalized area needs building of hospitals and schools. And now the most corrupt are now entrusted with construction. The transitional justice is now overlooked, which is a constitutionalized law, and anyone who overlooks this constitution cannot be the guarantor of the constitution. Normally, it's the president who is the guarantor of the laws and the constitution. Now, in order to understand what the president is up against or what the president is up to, it requires really a great talent and sorcery and witchcraft. His own social perspective, his own perspective of power and politics and of the history of Tunisia from 1955 up to the 17th of December revolution, as he tries to jungle with the dates, doesn't have any importance on his mind. He doesn't understand that the Tunisian state has continuity, that the state has violated the rights of its citizens, whereby it is required to repair the prejudice caused to these people. The state has to recover the stolen assets to provide for the reparation. It's a whole process that needs to be clarified. The last point I'd like to raise what remains is that if the picture is so bleak and somber and there's no glimpse of hope, because what initially said, in the absence of any political will, the financial corruption and transitional justice are so complicated and so full of hardships, but all of these difficulties shall no longer matter if we really have a genuine political will, and therefore the experts will be appointed in their right positions, and committees shall be established to resolve these issues. Will this happen? This remains dependent, of course, on, but we shall continue to be attached and committed to the process of transitional justice as a coalition of transitional justice. And our supporters from ICTJ, from the High Commission, the media institutions, and the free men and women, hoping that we shall overcome in this process and to get out of this crisis. Thank you, Mr. Riva. The defining issue is the political will that through which we could enforce all of the mechanisms to achieve the process of transitional justice. We shall take a 10-minute break and then we shall resume with the second session that will be run by the expert Ruben Carenza from New York. So let's take a 10-minute break. Thank you.
Should I start, Azhar?
Thank you. Please proceed. Yes, Ruben,
Sabahul-
please proceed.
Sabahul Khair. Shukran. Isaac. You cannot. Can you hear me now? Can you hear me now, Azhar? Okay. Okay. So that should work, right? Okay. So again, Sabahul Khair, good morning and thank you. Before I introduce the next panel, and I know we don't have much time, that's what I did. So now I'll just mute the audio. Can you still hear me?
Yes, we hear you well.
I don't know why.
Yes, we hear you. We hear you well. Yes, we can hear you. You need to remove the headset because you don't need to hear the interpreter. Just the ear set. The ear set needs to be removed so you don't hear the interpreter.
In order to explain the situation in our respective countries. The, I'm sorry, as for some reason I can hear the interpreter directly, even if my interpretation button is off.
Ruben, do you hear me? You need to click on English for translation.
Is there a way that the Imagine mic is muted on my end, because I can hear that. That's what I can hear right now. Yeah, I can hear all of you. It is clicked. It is clicked. So I don't know why it still comes in. Right now I can hear
There is
The
another button
interpreter
under English
in
and
Arabic.
Arabic. Deactivate principal sound. Or deactivate original sound.
Yes, I also
You need to
muted.
click on that button.
Yeah, there is off English, Arabic, and unmute original audio. Yeah, I checked that, and I still hear, the interpreter in Arabic. Let's see how to proceed. So as I was saying, I don't know, because in a few seconds I will hear the interpreter again. As I was saying, this question whether developing countries are poor because their leaders are corrupt, or are their leaders corrupt because they are poor, I think is a very narrow set of choices, because those sentences do not describe the situation of developing countries such as Tunisia. And so
Ruben, do you hear me? You need to deactivate the original sound. Do you hear me, Ruben?
yeah, I still
You don't hear me?
I can hear you, Azer. I can hear you, but the problem is after I speak.
You need to click on deactivate original sound, then click on
Yes,
English.
that's already clicked.
Okay.
I can hear you.
Okay.
I can hear you. The problem is
You hear the
a few
translation?
seconds after I speak. I can hear you, Azer. The problem is a few seconds after I speak, I then hear the interpreter in Arabic.
Okay, we are trying to fix that problem.
There's an echo, so I think it's echoing.
Mm-hmm.
It's echoing from there, so that it comes back to me, and I.
Okay.
Okay, so I'll resume now. I'll give 3 examples that might be useful before I give the panel some time. They're useful because they show us how anti-corruption rhetoric, the same kind of rhetoric that Kais Saied, the president of Tunisia, is using right now, can be used to promote policies that undermine democracy, that prevent accountability, and that reinforce inequality in a country. 3 examples of that. The first is Jair Bolsonaro in Brazil. When he was a candidate for president, he kept attacking the then president, left-wing president, and a woman, Dilma Rousseff, as well as the former president, left-wing labor leader Lula, with vaguely connected claims of corruption, claiming that they paid or they were given bribes by companies with construction contracts in Brazil. He appointed an investigator named Sergio Moro, was appointed by parliament. He charged Lula with corruption. Lula was convicted. He was sent to prison. But because Lula was the opponent of Bolsonaro, Bolsonaro won. He then appointed the investigator as his justice minister. And then, of course, we know what happened next. You have a fascist leader in Brazil whose vaccination denials and COVID policies has led to thousands, tens of thousands of deaths in his own country. And he continues to deny the effectiveness of vaccine, and he continues his fascist policies. And now he and his family are under investigation for embezzlement, for bribing parliamentarians, and for money laundering. So by using populist anti-corruption messages, Bolsonaro in fact undermined the progressive policies of Lula and Dilma Rousseff. Those are the two presidents of Brazil who in fact implemented transitional processes in Brazil. Dilma Rousseff was the president who led in the creation of a truth commission in Brazil that investigated Brazil's history of dictatorship as well as its history of slavery. Rodrigo Duterte, president of the Philippines, where I grew up in, he was campaigning, he promised to jail corrupt oligarchs, and then when he became president, he brought in his own oligarchs. He promised to investigate corruption. Instead, he jailed an opposition leader investigating his drug war killings, which have led to an ICC case right now. Duterte promised to investigate corruption, but then instead he gave honor to former dictator Ferdinand Marcos by burying him in the National Heroes Cemetery. That's the same Marcos who stole more than $2 billion to corruption during his 21 years of dictatorship. The Philippines now has one of the highest death rates in Southeast Asia, and Duterte himself is facing an investigation for overpricing COVID contracts. The third example of populist right-wing anti-corruption rhetoric being used by candidates and leaders to defeat accountability is, of course, very familiar to all of us, including even you in Tunisia. This candidate pledged to drain the swamp, had his supporters chant "lock her up" during his speeches during the campaign period, but now is facing charges for tax evasion. But the worst part, of course, is that over 500,000 Americans died from COVID during Donald Trump's presidency. So these examples show that we should not be seduced by populist anti-corruption promises, because corruption is not simply about greedy dictators or abusive politicians. I was part of the UN committee that drafted the UN Convention Against Corruption. And when we drafted the Convention Against Corruption, we defined politically exposed persons in a very broad way, not just politicians, not just presidents, not just prime ministers, but their family members, even their friends, the same family members and friends who will often portray themselves as businessmen or bankers or corporate executives. These are the same businessmen and bankers and corporate officials who have fancy houses in France. And then they go to Zurich in Switzerland to launder the money that Ben Ali stole from Tunisians. These are the same elites who will buy jewelry for Imelda Marcos in the Philippines, sell paintings for Imelda Marcos and launder her money. And these are the same politicians who will pressure Turkey so that Trump can build hotels in Istanbul. Or even the same friends of George Bush and Dick Cheney, who then got oil exploration contracts after the United States invaded Iraq or occupied Syria. So it's important to remember the connections between political leaders and the economic elite of a developing country. A developing country is not poor because their leaders are corrupt. Neither is it because the leaders are corrupt that they become poor, but it's a combination of corruption and inequality that leads to more corruption and leads to more inequality. Which is also why it's important to remember that corruption in the global south, including in Tunisia, happens because ruling elites control the capacity of the state to regulate its most important activity, from transportation to healthcare, from banking to natural resource exploitation. Some international financial institutions like the World Bank or the IMF will often tell developing countries that they should privatize the state's economic institutions, that they should liberalize their economy as a way to prevent corruption. But we know what happens when states do that. We know what happened when Tunisia did that under Ben Ali. More corruption happened, more grievances over unemployment, more grievances over marginalization. This is why the Truth Commission sent a letter to the World Bank and to the IMF asking them to contribute to reparations for enabling corruption committed by Ben Ali. They enabled corruption by Ben Ali by propping up his privatization and liberalization programs that allowed Ben Ali's family to control everything from tourism in the north to energy exploration in the south. It's important to remember this because much of the debate over corruption and transitional justice in Tunisia focuses on individuals, focuses on corrupt former officials, focuses on Kais Saied saying that he will do something about it. But Kais Saied has not acted on this letter from the Truth Commission. In fact, Kais Saied has not acted on the recommendations of the Truth Commission. So it's important to remember that corruption goes beyond individual politicians. Now, a last point. We should also not put all our faith in Western notions of democracy, equality, and justice. I know there's an ongoing debate in Tunisia over whether what Kais Saied is doing is a coup, whether what he's doing is unconstitutional. And of course, the other side saying that this is the way and the only way to hold corrupt officials, corrupt parliamentarians, corrupt businessmen accountable in Tunisia. You know, this debate only pits notions of democracy from the West with notions of what a failed democracy in the global South should do. But remember that democratic France never apologized for supporting Ben Ali. Democratic France has never apologized for its history of colonial control over natural resources in Tunisia. For the same reason, when we now see that Kais Saied has appointed the first woman as prime minister in Tunisia, there's a lot of discussion around the fact that it's a pioneering step, that it's important for gender equality in a country that has pioneered some aspects of gender equality. But really, is gender equality the pinnacle of equality? What will a woman prime minister who has worked with the World Bank, who presumably agrees with the World Bank, do about the role of the World Bank in enabling corruption in Tunisia? So today, we will hear from three speakers whose work has focused on what we in ICTJ believe must be part of transitional justice work: fighting corruption, recovering ill-gotten assets, and using recovered assets to fund reparations programs for marginalized regions in Tunisia. We must remember that before Kais Saied even thought of running for president, he actually once said in an interview in Arabic that I heard translated, he once proposed that assets recovered from Ben Ali's family should be used to fund development for marginalized regions in Tunisia. So my question before I let the panel speak is, why isn't he using his emergency powers to then deal with marginalization in Tunisia? So this afternoon in Tunisia, I will first ask my good friend, Swiss lawyer Niccolò Salvioni, who specializes in asset recovery, who is based in Switzerland, and with whom I have worked when I was in the Philippine government recovering assets of the Marcos dictatorship. He will talk about the implications of recent Swiss decisions to unfreeze Ben Ali assets and how these efforts are affected by the emergency situation in Tunisia. So, Niccolò?
Okay, yes, I'm online. Do you hear me? Do you hear me?
Yes, we hear you clearly.
Okay, great. So thank you very much, Ruben. Mohamed, distinguished speakers, judges, was very interesting to hear from the North the huge problem you have to deal with the past, the present, and the future. And the asset recovery can help with the future, but it's necessary to deal with with the present, with efforts that has to be done, and with structures that functions. And as I have heard until now, a big problem is the fact that unfortunately the structure can't function as they should, especially the judiciary function. And the big problem is that we are dealing with two different words. So the Swiss judiciary structure function in a way that needs some inputs, and the inputs should come from Tunisia. And in order to have those inputs, Tunisia should prepare specific requests, should take specific decisions. And if they can't do that, the inputs are not coming in Switzerland, and Switzerland risk progressively to unfreeze what was frozen 10 years ago, like it happened in January this year. And now I'm just I will not read a draft paper I prepared. I have sent it to Mohammed. And if somebody is interested on what I have written in this paper, you can ask to him in order to obtain him. But so I focused on 3 points in my brief speech. So the first point is that what's this administrative freezing and unfreezing in January of this year meaning? What's the meaning of this decision of the Federal Council of Switzerland? And the second point is quite interesting and very important, especially with regards to the fact that the two systems, so the judicial system of Tunisia and the Swiss system of the judiciary should match each other. What means to work with exceptional measure and powers, and in how far they can go in order to permit that a decision taken also in such regime can be accepted in Switzerland in order to proceed to bring the money that is in Switzerland in Tunisia. And the third aspect that I wanted just to mention is a recent amendment of the Swiss law on international mutual assistance in criminal matter that opened to the collaboration with international courts or inter or supranational institution with criminal justice function, and gave to the Federal Council the right to accept this collaboration through a decree. So that's a sign of trust from the Swiss Parliament to the Federal Council that could give the possibility to open the collaboration to other international tribunals, not the classical ones, the one of the United Nations and the Court of Rome, but had not an effect as far as recognizing also the institutes of transitional justice as partners for request of mutual assistance in criminal matters in Switzerland. Maybe regarding the administrative unfreezing, it's possible to mention a recent statement by the Swiss Office of the Attorney General of Switzerland, it's the OAG, that mentioned that in the context of the Tunisian revolution, that the Office of the Attorney General of Switzerland has opened several criminal proceedings since 2011, and recalls also following points: that there has been conducting criminal proceedings since 2011, since the direct aftermath of the events of the Jasmine Revolution that occurred in Tunisia between 2010 and 11, against members of the entourage of the deposit president, in particular, for suspicion of money laundering. At the beginning of those complex and extensive proceedings, a total of 14 defendants and unknown persons were involved, as well as 11 natural persons who were seized, and third parties, and 10 legal entities who were also seized as third parties. And in addition, some 74 accounts and 48 topical banking relationships were investigated in this context. In April 2016, the Office of the Attorney General of Switzerland made an initial restitution of approximately 250,000 Swiss francs to Tunisia. In addition, in April 25th, 2017, a waiver of sequestration on banking relationships was ordered for an amount of approximately 3.5 million euros. This was transferred to the Tunisian state. And finally, also in one of the criminal proceedings, the Office of the Attorney General ordered on December 11, 2017, a partial closure in connection with 3 defendants, a closure that came into force in October 2019. The Office of the Attorney General concluded that for those 3 persons, the conditions for a criminal prosecution were no longer met. In December 2020, the Office of the Attorney General lifted the sequestration and ordered the restitution of the amounts concerned to the Tunisian state. It asked approximately 600,000 US dollars and 580,000 euros, respectively. Those decisions are currently being implemented, and today the Swiss criminal proceedings in the context are still in progress against 11 persons and unknown person. The amount of the sequestrated assets amount to approximately 50 millions. And according to an article of the Federal Department of Foreign Affairs, at the beginning, the amount that was under sequestration was 60 million. So the difference is of 10 minutes from 10 years ago. And in the meantime, the Swiss federal jurisdiction has established mutual assistance with Tunisia in several cases. And also several Tunisian rogatory letters came to Switzerland to be executed. And at the end, the Office of the Attorney General remembers that the procedure is, those procedures are criminal procedures, that they can't be referred in details. And they are independent, and they are specific subject of criminal procedural rules. And what regards the Federal Act on the freezing and restitution of illicit assets held of foreign politically exposed person, that's in the domain of the Federal Council and the Federal Department of Foreign Affairs. And therefore, they should, in case, give indication about that. And then the end, mentioning the presumption of innocence of the defendants. That's clear. So maybe that was in a resume of actual statement from the Office of the Prosecutor in Switzerland. Regarding the Swiss Department of Foreign Affairs, they also had to release those money because the 10 years was a statutory period and they could not continue to unblock them. But they end writing that the expiration of the Federal Council freezing order does not alter Switzerland's willingness to return assets proven to have been acquired illicitly. Switzerland will continue to support the asset recovery process. So that's really a nice statement. Maybe with regard of the prosecution, probably you have already seen or you will see that today, finally, the Swiss Parliament decided to give the charge as the Attorney General to Stefan Blätter, which is the former commander of the Cantonal Police of Canton of Bern. So finally, after more than 1 year, Switzerland has a prosecutor general, and that is surely a good sign in the direction also of the collaboration. Maybe regarding the second point, regarding the possibility to take special measures, I could simply remember that Article 1A of the EMAC, that's International Mutual Assistance in Criminal Matter Law, states that in the application of this act, Swiss sovereignty, security, public order, or similar essential interests must be taken into account. And Article 2 of the same statute says a request of cooperation in criminal matters shall not be granted if there are reasons to believe that the foreign proceedings do not meet the procedural requirements of the European Convention of Protection of Human Rights and Fundamental Freedom of 1950, or of the International Covenant on Civil and Political Rights of 16 December 1966. So the problem of that could arise special measures is if they shortcut too much the rights of the defendants. The problem in this case could be that Tunisian decision that has been shortcutted because of necessity could be object of complaint in Switzerland, saying that that's not a correct decision because all right was denied, and therefore the risk could be that Switzerland could not accept it for this reason. But I don't think that this is a danger that is impossible to it's impossible to solve. I remember that, for instance, in the Philippine case that Ruben Karantzen mentioned, the PCGG was founded the Presidential Commission on Good Government on the Presidential Order #1 was the first thing that Corazon Aquino did in his presidency. And then afterward followed Order 1, and this structure was strong connected with existing bodies. And at the end, the procedure had a success. So it is not impossible that special presidential powers can also give a good line in order to solve the problems. And that was the second point. And the third point just mentioned, that's a new paragraph 3B of Article 1 of the EMAC, the International Mutual Assistance in Criminal Matters, that opened the possibility for Switzerland to give assistance also in international, or supranational courts with criminal justice function. Unfortunately, it's not yet an opening to a direct collaboration with transitional structure bodies, but it's a good sign of goodwill from, I think, also from the Swiss Parliament to collaborate better with the foreign state. And I think that's everything I had to say. I thank you very much for your attention.
Thank you, Nicolo. I will not take long. So our next panelist is someone that ICTJ has worked with many times. And I think she brings a perspective that's important because it is a perspective from activists who have worked on inequality in Tunisia, who have worked on addressing marginalization in Tunisia, who have worked on looking at corruption beyond the greed of politicians. And she spoke earlier and said as much, and I think she can elaborate on that. So I'll call on Laila Riahi to speak next.
Hello, everyone. Thank you, Ruben, for this nice introduction and presentation. I thank all the valuable papers presented here that are likely to help us as civil society activists. That is the other side of the story, if you want, the activists within society and outside the realm of official institutions for the sake of countering the system of corruption in all possible ways. It is true that on many occasions I was directly focused on corruption issues, but my interest was not limited to the embezzlement or to the bribery issues, but I was focused on the extent to which the political and economic system is generating corruption in Tunisia. This is the perspective that I try to address in depth through my field work along with my colleagues. We are not focusing on corruption as a case, but we notice that corruption is the result of a set of mechanisms, decisions that are present today and that are helping the corrupt system to continue and to be reinforced in a way. I'd like to remind that countering corruption during the transitional period is a public or is an issue for society, cannot be an individual issue or an issue for an institution. It is about the expectation of an entire people that really expressed its total exasperation, its total rejection of a developmental paradigm that put forth and created an economic class that is hiding behind a political class that makes all forms of corruption a way of reaping direct and indirect profit through their positioning in a system that is totally based on policies and options that per se generate corruption. I wanted to speak a little bit about the economic paradigm that we are adopting in Tunisia to highlight this idea. Our economic paradigm in Tunisia is based on various sectors, basically the mineral sector that require cheap labor, where the cheap labor is an important competitive edge, like agriculture, textile, and it is based on privatization, which is imposed by the IMF and imposed by the requirements of the World Bank and other financial institutions that keep coming back on any crisis to impose the structural adjustments, pushing towards the same direction. The banking sector and the financial sector that is inflated the number of banks in relation to the per capita statistics shows the deep inflation in addition to the consecutive governments that are based on these systems in order to attract foreign investment and to boost the economy. On the other hand, we have a national economy that rests on small farming, on small industries that is suffering from the hegemony of small companies and dynasties. We have an oligarchy that is controlling the economy in terms of the finance, relying on the banks and on the political level, because they are relying on the connections. For instance, the employers association and the farming sector, the entities that set the prices, and these small groups that managed to keep a firm grip based on their connections, direct connections with the financial institutions, managed to have a firm grip on the economy, making the economic system non-productive and generating bribery and corruption and embezzlement, and the authority of cartels and lobbies that in the end, even for the young people in Tunisia, be it under the Ben Ali regime, their dream is to become a part of the Trabilsi connection. The system as a whole, I'm not referring to some individuals who are adopting corrupt behavior, who are referring to a financial, economic, and political system that generates corruption. We as civil society, if we consider the civil society in its broad sense, from the social movement up to the organizations, dealt with this issue with all different kinds of methods. If I come back to 2008, the Al-Daif movement, the movement was sparked off by the issuance of those who will work in the company. And the first issue is that there was a huge corruption and bribery going on with regards to the job hiring in the phosphate company in Al-Daif. If I refer on I Watch Observatory, the Tunisian Observatory for the Economy, these associations working on these issues, even at the level of local level, at the community level, there were so much corruption rigged the procurement process in terms of the tenders given to specific people, and therefore among the requests made and formulated by the people, by all people from all walks of life, all of those who moved in the industrial and agricultural world, they asked for the collapse of a corrupt system, and none has asked to hold to account the corrupt people behind this corruption. Therefore, the main public demand is to change this developmental paradigm and to dismantle the system thereof. And I would like to reiterate an issue that keeps coming back whenever I talk about transitional justice and the expectations from transitional justice. This recurrent issue that is a defining issue and should be included in all of the processes that are known by some countries like Tunisia is to the auditing in the loans. You cannot bring together forces and set up a balance of power strong enough to change the developmental paradigm without this comprehensive vetting and auditing regarding the policies that have been pursued, the contracts and the that have been made. There is the citizen auditing that starts from a small project for the building of a small road going to contract for that. The institutional vetting also is of paramount importance. We've proceeded with an institutional vetting in terms of the public banking, but it has never been published. And I know that such auditing contains enough information to dismantle a large part of the corruption system, especially the one associated with the projects financed from abroad. I'd like to remind that in Tunisia, the Truth and Dignity Commission sued the IMF and other countries proceeded with auditing, showing how much funds that come within the framework of developmental projects, these funds end up abroad in smuggled out of the country in different ways. And in my opinion, this is the kind of field and on-site institutional research work that would enable us to have a clearer picture of those who are really insisting on maintaining the current system and who are keen on changing the system. Those who are insisting on this system are the enemies of the people of Tunisia and the enemies of the Tunisian citizens. And it is not acceptable to deal with this category of people through the idea of transitional justice and amnesty in return for investing in marginalized regions. This is not the best rationale to go about. What is requested is to review the overall policies. You could produce a car that is economical, and you can produce a gasoholic car. Our economic system is squandering our resources. I can relate to other numerous examples. The rehabilitation program, the industrial upgrading program designed to the upgrading program. The industrial upgrading program was pursued in 1995 after signing with the European Union. Now, Tunisia obtained grants and loans, huge loans, in order to scale up our industrial fabric and tapestry. We tried to really find out where these funds ended. These funds enter the central bank, from which it is dispatched to 6 banks, and these banks dispatch them to the company owners, most of whom are bank owners. And all of this, and then the country grants it in the form of privileges to the same dynasties and families. This is what corruption is all about. I don't mind smugglers entering 2 trucks of petrol on a border crossing that historically has lived and survived on border crossing trade. This is not the huge part of corruption. What affects us most is the corruption that really constrains our economy and binds it to this corrupt system. The absence of this important foundation of transitional justice, I do not understand that there should be transitional justice. Justice is justice. Why should we be relative? Just like democracy cannot be relative. In transitional processes, when we embark on a relative democracy, there can be no democracy in the end. Likewise, when we embark on a relative justice or transitional justice, there is no justice. The basic principle or foundation is truth seeking and unveil the system before really reparation and reconciliation. To unveil the truth, we have to publish information and pave the way for anyone that has expertise, even any to contribute to this auditing or this vetting that could be citizen-based or institutional, or it could be a hybrid system involving national and international organizations. This is a very important part in terms of defining responsibilities. In addition to requesting that those who committed crimes and embezzled funds to be held to account, we have to hold to account those who made wrong decisions knowingly, and this can be established today if only we focus and devote our resources, our civil society, to also the media also have a key role to play. My colleague later on will dwell on that. Anything you can pinpoint, you will really find that in the backstage, corruption is pervasive, and to address all of these issues cannot be resolved through the judicial system. It's a process that will take time, but most importantly, those concerned in this have to play the key role to request change. How many cases and how many laws have been promulgated without being enforced because those concerned with this law are not advocating it genuinely. And what we have witnessed in Tunisia is that this transition from government to government, from election to election, any group reaching power, their main objective is to really have a firm grip on the steering wheel, which is corrupt, and then they cannot really repair it. Even if there are enticements and really pull and push from different sides of Mabrouk and Ben Ayed, are those who are really pulling the strings. I hope I haven't been too long in my presentation. Thank you.
Isaac, Leila. And I'll go quickly to our next panelist. Awel Unifi writes for Al-Katiba Journal, and he's a journalist who has specialized in corruption questions, and that's not surprising because he worked for some time at the Anti-Corruption Commission of Tunisia. And I'm aware that Al-Katiba actually has recently published the results of its surveys around what Tunisians think of the state of emergency declared by President Kais Saied. So I think he can talk about that, and he can talk as well about how this impacts on the role of journalists in looking at anti-corruption work under this current state of emergency. So I'll let you speak, Awel.
شكرا على الدعوة مرة أخرى وعلى إتاحة الفرصة للمشاركة في الورشة هذه اللي راها مهمة.
Thank you for the invitation, and thank you for giving me the floor to speak. When I speak about investigative journalism, I can talk from the point of view of institutions and from the point of view of politics, but I consider myself as one of the journalists that emerged after the revolution. Before the revolution, I did not consider myself as a investigative journalist. And we have started our real investigative work after 2011. So in order to get to the situation of investigative journalism and then to the exceptional circumstances that we have right now, I need to remind you that in 23 years we have been under the dictatorship, and we did not have in-depth journalism or quality journalism or investigative journalism. We had limitations in audiovisual production, etc. So we only had those institutions that are based on one political party and one person, and we did not really have a momentum for journalism to open up on what is happening and to of course take a closer look to the Ben Ali family and to the Trabelsi family. So we also looked at the TDC report, and we saw how much corruption was involved, and how much it was spread. And that's what led, at the end of the day, for the toppling of the dictatorship. So the journalists before the revolution did not deal with politicians or politics in general, but suddenly they found themselves dealing with such topics. 80 and 90% of journalists before the revolution only dealt with journalism for the course or football journalism, etc. So nothing was related to the regime. After the revolution, things have changed. The same journalists, without being trained and without any continuous training, they delved into complicated and complex political situations, including corruption. Of course, when people are deprived from something and then they get it, there will be an eruption or a sudden eruption of articles. And in Tunisia, we had the transitional process during the same time of a digital revolution. So this led to us having to cope with the revolution, digital revolution and social media revolution. And at the same time, we had to withstand the momentum created by such platforms. We know today that Facebook pages have a huge impact on people and on and we know that some people related to journalism say that they are investigative journalists, etc., and they are investing in that. They even created media companies. Some of them have been exposed and have been shut down, but others are still active on social media. So they, of course, such institutions, they will just hold up the banner of anti-corruption and will try to do their own investigations. So this created a confusion for the citizens. The citizens no longer distinguish the real investigative journalists from the pretend ones. So since the beginning of investigative journalism in Tunisia, we know Mejri, Hanan Douil, they are the first people who worked on investigative journalism in Tunisia and founded the pillars of this genre of journalism. So how can this type of journalism come in handy? We spoke about that some people are using the facade of investigative journalism to create chaos. Some people, as I said, are confused and they don't know what's really happening. So the issue is that people would always call media as a media of shame, for example, because of such fallacies. The other thing that I would like to talk about are difficulties that we face as investigative journalists. So I have lost my train of thought, but let me think. To go back to the role played by investigative journalists, we need to understand that many journalists are working on such endeavors from Nawad blog, from Al Hiyaz, from our website Al Katiba. We have been active for 1 year now, and we have had a lot of articles and investigative campaigns as well. So this is something that is being conducted by the journalists. But what is the impact of all of this effort? Is there a real influence? Are the public getting the fruit of investigative journalism or not? So this is the question that we're asking. Even when we have high-level topics, they will only be looked at by the elite. So, for example, we can speak about a case, and then there were pledges by the relevant entities, and then there is no follow-up. We all know that in 2016, the Intifada website issued a report on the Panama Papers, and the relation of some people to accounts in Panama. So an investigation was started. Journalists have been invited in order to be heard at a hearing, and to get to know the information they have related to this topic, to the Panama Papers. So, of course, all of this happened. The Parliament appeared to be doing something, but then there was no tangible result. Even when we issue our investigative article in an opportune time, and but the problem is that it is not conveyed to the intended audience. The investigative journalism certainly works better with videos, for instance. And this is the way to influence and to get the relevant authorities to open up and file cases. We're trying to our best, and the media that we're using as investigative journalists are mainly related to websites. Even when we try to produce some text to the wider public, but we find that only the elite will be interested in reading the whole article. Our objective that we want to get to in our website, the Katiba website, is to reach the wider public, and we can do that through documentaries. We film documentaries that would be 26 minutes, 27 minutes, etc., depending on the topic. And this is a more tangible media or medium of information that would get to the people more. But as you know, this costs a lot of money, but at the same time, we like very much to be influential. If we look at the example of one media, investigative media, we have had Al-Anwar. Al-Anwar has, for example, produced a video investigative video, which has been broadcasted on the Four Truths program, TV program, and this created a huge echo. And this kind of echo and this kind of response could have never been reached through written articles. At the same time, when we shoot videos, then we have interactive reactions, and which is richer than text. So all of these things are actually happening right now, and I would like to link this to transitional justice. Transitional justice and the cases that have been referred by the TDC are complex, and we as journalists, we need a lot of time to dismantle and to look at each detail of these cases. When we look at corruption in the banking sector, it's a case that involved officials who are still operating nowadays. There are people who committed financial crimes in the previous period, but some of them are still operating. Some of them have had some prominent positions. Some of them also are wanted by justice. And the issue that we had, especially with the MPs, is that they had immunity. Some of those people became MPs just to get that immunity. And therefore, the danger emerged, especially when we find someone who is involved in finance or a consultant to the Prime Minister on economic and financial issues, and they are suspected or have been confirmed as conspiring or as committing financial fraud or financial corruption. So this further complicates things, and the head of the commission can also confirm this. And we as journalists, we can no longer pinpoint the origin of the problem. And the best way to go is to analyze such information. However, as we said, the information is so complex that we cannot do it ourselves. We would require legal assistance or legal support to do that. When we look at the cases dealt with by the TDC, they have highlighted the complexities of crimes and how they are committed, because that's the important thing to see. How are the cogs turning? How, for example, money is smuggled, etc. But when we look at this jargon, then only the experts, the financial experts, would really grasp the meaning, and therefore investigative journalists would not have the right tools to understand all of that. So that's why there needs to be assistance provided to the journalists to be able to adequately analyze such information. And if such constant assistance is not available, we need to train the investigative journalists to do so. At the end of the day, we need to reach accountability. It's our final objective. Everyone would like to get to that point, including civil society, the journalists, the citizens, etc. And this should be emphasized on with the decision makers. All of these stakeholders, they should go together towards this common objective, and there needs to be real partnerships. We should not only organize training courses and that's all. We should move together more and create a core of investigative journalists and look at the indicators. maybe you would say we have trained 900 investigative journalists, but at the end of the day, after 2 years, they only find like 20 or 30 articles. So this is not an omen of or a sign of success. We need to have follow-up. Thank you very much.
Thank you, Isaac. Well, I know we only have little time for questions and answers. How much time do we have for that, Azef? So what I'll do is I'll let
We exceeded the
Azef
time, Ruben. So
get the questions that are
but we
in
can
the
still
chat
have.
box. If there are questions on Facebook, we can just read it aloud instead of having people go on camera and ask questions, because that will take time. But I'll just ask one question and I'll start from each of you. And I'll start with Wael, who spoke just now. You said earlier in the first panel that you think the president, Kais Saied, is going in the right direction in terms, I assume, of his anti-corruption statements. And I don't know if this is something that was translated correctly, but that's how I understood it. And I wonder whether you can reconcile your assessment that he's going in the right direction with the idea that he is also acting unconstitutionally. Can those two things go together? Acting unconstitutionally and going in the right direction in terms of addressing corruption? Oh, well, our last speaker. Unless I made a mistake and I did not understand that it was not him who said that. But in any event, maybe that's a question to ask him. How can this be reconciled? Someone who promises to address accountability for corruption, at the same time carrying it out in an unconstitutional manner.
In my previous intervention regarding the exceptional measures taken by the President of the Republic, I did not approve of all the measures taken by the President of the Republic. Maybe the lecturer believes that the process is the right process, but I believe that the system of the 10 years of this transition to democracy created some disruption at the level of all institutions, the judiciary and the other bodies. Even the public policies are not known in terms of their designing. This is a truth that is visible, but this individualistic approach cannot build a genuine democracy. And I believe that the President of the Republic is rejecting any mediating bodies like the media. And this is a real issue that will be added to the new process that Tunisia is embarking on, because since the arrival of the President to power, he never talks or meets with the journalists, and he may probably consider them as part of the corrupt systems or those who have harmed the country. We do not have any different characterization. There are some media institutions that really harmed the life in Tunisia, but putting everybody in a single basket is really a dangerous approach. And it is some of the populist speeches and discourses. The other issue regarding the exceptional measures, especially the ones included in the interim provisions of the 25th of September in connection with the freedom of printing and publication and media. We are expecting the President of the Republic to proceed to a genuine confrontation by confronting the state institutions, but to include the media and the freedom and of publication and printing among the procedural rights to be governed by presidential decrees. This is what I really feared, and this is what I disliked about the new process embarked by Tunisia, because there are things that are still fuzzy, and the speech of the president is not reassuring, even though it may carry the will for more ways of combating corruption and for a better course towards democracy. But intermediate bodies have a role to play, including the media and the journalists. They have the role of holding to account the political authorities, even if that meant the President of the Republic.
Thank you. And I apologize if I was confused in asking my question, but that was a brilliant way of describing the implications of this state of emergency on journalists. My next question is for Nicolo, and then I'll ask Leila as well. But for Nicolo, you talked about how very restrictive measures by a president might be seen as denials of due process from the perspective of Swiss authorities who are looking at asset recovery, who are asking Tunisia to provide judicial decisions that show Ben Ali was corrupt, his family members were corrupt, and these are the decisions. And I understand that, having worked with you in the Philippines cases that required us to produce a judgment showing that Ferdinand Marcos and Imelda Marcos were corrupt. But I'll give you a separate way of looking at this. If there are delays in deciding cases of corruption, including cases of corruption involving assets in Switzerland, wouldn't Swiss banks be happy that they get to keep the money, that they get to profit from it? And therefore, a state of emergency that might not lead anywhere in terms of judgments from the Transitional Justice Court in Tunisia, for example, it means Swiss banks will continue to hold Ben Ali's assets, and Ben Ali's family members, because of the unfreezing, will be able to access those assets.
And also the criminal procedure has time limitations. So this unfreezer was an effect of the first general administrative freezer ordered by the Federal Council. So it's necessary to evaluate from a case by case how the situation is. For me, it's very difficult to say what will happen. The problem, as we have seen in other cases, if the country delays to decide, normally after the time limitation of a theoretically accusation for money laundering or other crime, the judge could decide for every single case to unfreeze the frozen money, and that's a risk, and it depends from a lot of elements if that will happen or not. It's clear from the political point of view, for Switzerland to unfreeze money because you have time limitations and the country that requires mutual assistance doesn't act, is not nice. And that's exactly the problem of the two systems that could find a way to fit between each other. And the problem at the end, if the Tunisian prosecutors or responsible officers can't give evidence that the money that is frozen was a product of a crime, unfortunately, the Swiss authorities will have to unfreeze them. So that's mathematics, unfortunately, and therefore a sane and effective prosecution system. That, by the way, I think it's possible to have it also with special measures A special measure doesn't mean that the rights of the accused are denied. Special measures could mean that the judicial bodies finally has the necessary energy, funds in order to make what they should make. And that's it. And if that's not a denial of rights, and is necessary to see if a measure is colliding with the European Convention of Human Rights, then it's better to avoid to take it. But if it's not colliding, and it would be also possible to discuss, I think, with the Federal Department of Foreign Affairs of Switzerland to see if a measure that is aimed to sustain the judicial body in Tunisia has to be taken. Would that jeopardize or not the request of mutual assistance in Switzerland? And it could be also possible to make expertise on that. And then if you find the right formula, maybe you could reach a decision that permits, maybe not in all cases, but in the main part of the several cases, to speed up the procedure in a way that is respectful of the rights of defendant, and that permits to obtain a request of unfreezing to benefit of the Tunisian government in a reasonable time.
Thank you, Nicolo. That's helpful, and I agree that special measures don't have to be measures that violate due process rights. They are special because transitional justice is in many ways special. That's why Tunisia has transitional justice courts. They don't violate due process. They just focus on transitional justice cases. So now I'll turn to Leila, and I know this will sound like an unfair question, but alongside today's news about Kais Saied appointing Tunisia's first woman as prime minister, you always have these sentences in the news report saying that Tunisia is also waiting for the IMF to approve another round of borrowing that will prop up Tunisia's economy, especially during the pandemic. And there's this suggestion that a woman prime minister who might be familiar with World Bank policies will be someone who is acceptable to the IMF, something useful in dealing with the World Bank, and therefore beneficial to the Tunisian economy. What do you think of that argument, Leila?
Quite frankly, the nomination of the head of government, the choice of a woman, because at the international level, this would be better perceived and accepted due to the criticism sustained by Kais Saied due to his past opinion about parity and equality, and the last decisions and measures taken. All of the decisions are rendered in a dictatorial way, and therefore there's no way to appeal these measures. He has embarked on a course that cannot be characterized as a democratic process. I, on the other hand, have been following Kais Saied for many years because I have noted his presence on the field through the different visits to some poor neighborhoods, and he has been always there. And I always noted the reactions of the people. I noted what I know is that he has no economic perspective at all whatsoever, and even the groups that he relies on for advice has been changing constantly, and these advisors are not known. We don't know who he seeks advice from. What we know is that he has no advisors or consultants specialized in economic matters. The choice of a person from within the administration, because she is from the administration, she has been present under negotiation frameworks, negotiations with the IMF and the World Bank in the objective-based management unit. And in my humble opinion, if she is going to be present within the objective-based management, she will not add nothing to the situation of Tunisia, and she will come up with no economic solution, be it at the local or at the national level. We do not expect solutions, and we don't expect from Qais Said to come up with any political or any economic agenda that would put Tunisia on the right economic track. My biggest concern is the renewed frustration that may befall us, and I don't see any possibility through the way economic matters are being dealt with. I don't see any breakthrough for Tunisia.
And on that difficult note, I will turn it back to Azer, because I know we're late and running out of time. So Azer.
Thank you, Ruben. I thank our honorable guests who have really enriched our session with their valuable presentations. I'd like to thank the speakers online, Niccolo Salvioni, and everyone who has contributed to this important meeting. We thank even those who never raised their hand to take the floor also. Please stay safe, and we shall meet in upcoming workshops very soon, I hope, regarding ways of countering corruption and the recovery of ill-gotten assets and stolen assets. Thank you very much, and goodbye, everyone. We shall meet very soon.
Hi, Check.
عايشكم عايشك